Buluvinaka, I am Niko Nawaikula. I am candidate number 150 for Sudelpa. I am a lawyer by profession, and my area of expertise is in relation to land laws and the law relating to the rights of indigenous peoples. I would like to speak to you today on some very important and critical issues that are critical to me personally, that are important as well to the indigenous community of this country, and of course, which will impact largely on the public at large. The 17th of September is now fast approaching, and it has now emerged that the issue in this election will concern the rights of native Fijians generally and the rights in relation to their land. Now, this is a matter that is of concern to me. It is also of concern to the indigenous population of this country. It is also of concern to the general public at large because it impacts on national building. Now, it has been very clear to me from reading the Constitution and from looking at the laws that have been passed by this government since 2006 that the dissemination or dismantling of the institutions of indigenous Fijians in relation to their rights and their land is one of their policies. It has also been confirmed to me that this is so at the meeting that I attended in New York in 2010 on the rights of indigenous peoples, as well as at the meeting that I attended in Geneva on a UN Human Rights Committee at the request of the Marama Rokutuindakeci and the Turanga Tuirakau. I want to spend a bit of time now to go through the 17 decrees that have been passed by this government from 2006 until now that is intended purposely to remove the rights of indigenous Fijians. Having said that, let me say that I have read the conclusion of Mr. Kayum's thesis, and looking at that, together with the 17 decrees, it confirms to me the determination that this government has gone through to implement the thesis of Mr. Kayum. Now, these decrees, I have a copy here, and I have copies of the laws too that are part and parcel of these decrees. The first decree that came into being was the Fijian Affairs Great Council of Chiefs Regulation of 2007. This law suspended the Great Council of Chiefs. The purpose and intent was very clear. It was to allow the government to do what it likes and what it wants to dismantle customary institutions. When the government cannot or did not obtain support from the Great Council of Chiefs, it passed another legislation or another law in 2008, which is the Fijian Affairs Great Council of Chiefs Regulation. The purpose of this law was to take away from the Great Council of Chiefs, as well as the Fijian people, their power that were vested in them to appoint members into the Great Council of Chiefs. Having taken that away, it vested the same power single-handedly on the government of the day. And the purpose is clear to anyone. It is to allow the government to put in the Great Council of Chiefs people that will say yes to it. Now, the second law that it passed was the Fijian Affairs Provincial Amendment Regulation of 2008. This law took away or removed totally from the Great Council of Chiefs, as well as the Fijian people, their power to decide and determine members to sit in the Fijian Affairs Board, as well as the provincial councils. Having done that, it took away their power, and then it vested that power alone into the government, so that the government becomes the sole appointee of members of the Fijian Affairs Board, as well as the provincial councils. Why did it do this? It is very clear. It will be very clear to anyone It is to allow the government to appoint people who will say yes to it. And the implication was clear when the government came along with a document that it called a charter. Native Fijians expected or thought that the Provincial Council, as well as the Fijian Affairs Board, will stand up to the government to tell the government that the charter is dangerous, or the charter is critical to them. But they were surprised to see that the very people that they thought would stand up for them were bringing the charter and promoting the charter to the villages and to their provinces. The fourth act, or the fourth law that the government of the day passed, was the Fijian Trust Fund Amendment Decree of 2009. This law removed totally from the Great Council of Chiefs the power that it previously vested in it to look after a sum of money, which was the Fijian Trust Fund, to administer Fijian administration. So by that legislation, the government took away totally the control of that money and vested in it alone. The fifth legislation that the government passed was the Native Land Trust Amendment Decree number 31 of 2009. This legislation removed totally from the Fijian people their power to control native land. How the legislation did that was that it removed the power of the Great Council of Chiefs, as well as the Fijian people, from appointing members of the Native Land Trust Board, and then it gave that position to the government, that sole appointing authority, to the minister. So from that day onwards, only the minister, only the government can decide who sits in the board of the Native Land Trust Board. And I can assure you and I can confirm to you that from that day onwards, the native owners of this land no longer have the control or the power to manage their land, as it has passed by that legislation to the government alone. The sixth legislation that the government passed was the Native Land Trust Regulation Amendment of 2010. This law took away from the chiefs, or from the Turanga ni Matangali, from the Turanga ni Abusa, the Turanga Itoki, their share of royalty. How it did this was to pass a regulation which was called the Native Land Trust Regulation of 2010, and remove totally from the authority of the Native Land Trust Board the distribution of this money. The next legislation that it passed was the Mahogany Industry Development Decree of 2006. We all know that under the Declaration on the Rights of Indigenous Fijians, indigenous people, it was confirmed that native owners, and in our case native Fijians, should own and manage their land. And from 1940 onwards, this has been the sole responsibility of the Native Land Trust Board. This law took away from them their right and placed the right to manage mahogany leases, as well as the right to determine fees and royalty in relation to mahogany on another board that is comprised by only 4 people, including the Prime Minister and the Attorney General. The decree that came after that was the Regulation of Surfing Areas Decree number 35 of 2010. This law took away from indigenous Fijians their right over their fishing areas, where the government wants to set up surfing business. So what the legislation does is that it took away from them the control and the right to fish in those areas, leaving it alone to the government. So that wherever before the government or the Native Land Trust Board would ask for the authority and the consent of the native owners before it leases out land for surfing, this law has totally removed that and taken that away from their hands. The next legislation that the government passed was the 2010 Fijian Affairs Decree number 31. This legislation took away their name and replaced it with another name, which is Itoke. Now, the consequence of that is that for native Fijians, the Fijians would imply knowledge of custom, knowledge of language, knowledge of customary practices. But that been taken away with the government giving to them another label that are totally alien to them. They were not consulted for this. They were not even obtained the authority or their consent, and it was done contrary to the right that were conferred to them under the UN Declaration of Indigenous Rights, which require the government of the day to first consult them before it passes any legislation. The 10th legislation that this government has passed in relation to the removal of their rights was the Native Land Trust Amendment Decree number 32 of 2010. This legislation removed from the Native Land Trust Board the president as the president or the chairman. Now, from the time that the Native Land Trust Board was established, the Great Council of the chiefs and the indigenous Fijians have always known that the chairmanship of their board was vested or was referred to for their protection to the Queen, who had been sitting as president of the Native Land Trust Board. When Fiji became independent, that role was transferred to the Governor General. When Fiji became a republic, the president overtook that role on behalf of and to see that the interest of the native Fijians and the chiefs were at all times protected. Now this law, being the Fijian Affairs, the Native Land Trust Amendment, Decree number 32 of 2010, has taken that away totally and has placed the government of the day, or the minister, or the prime minister now, to be the president and chairman of the NLTB. So there you have, by these and the other laws, he is the chairman and president, prime minister, and he also appoints the members of the Native Land Trust Board. The legislation that came after that was the Native Land Trust Amendment Decree number 20 of 2010. Before, native Fijians have known that every time a Matangali becomes extinct, the ownership of that will revert back to them as owners. This law has taken that away and has placed the ownership of extinct Matangali lands back into the hands of the government. Then, in 2012, the 14th decree, Decree number 14, that this government passed and put into effect was the Itaukei Affairs Amendment Decree number 22 of 2012. This is the decree that has terminated totally the Great Council of Chiefs. The implication of this is that you no longer have the Great Council of Chiefs, and the consequence of that, but the concern on that is that under the ILO Convention 169, as well as the UN Declaration and Convention, native Fijians have the right to maintain their customary institutions. This law is being made, as well as the totality of the 17 decrees, are made totally against their rights that are conferred to them under the UN Declaration. The 16th law that this government has passed was the 2013 Constitution. That law, as I've said, has removed totally the entrenched provision, which means the government of the day does not have to obtain their consent or get their approval before it passes any legislation, as well as, in addition to that, Section 6(5)(c) of the 2013 Constitution has allowed or has given a leeway to the government to remove the protection it gives on native land. This is proof to us all that this government is determined to remove the rights of indigenous Fijians. This is also proof, it was also confirmed to me when I attended Geneva in 2012 and submitted the list of this legislation to the UN Human Rights Committee, the answer or the explanation that the Fiji representative gave to that Human Rights Committee was that they have passed these laws in accordance with the policy of government that is reflected in the Charter to bring about equal citizenry and to remove manifestations that will bring about discrimination. Before I end, let me share with you the statement that was made by the Committee for the Elimination of Racial Discrimination, which is a Human Rights Committee at Geneva, that was directed at the Fiji government representative in August of 2012. And it said, and I quote, "The passing of policies and laws to dismantle customary institutions, to take away their name, and to take away the control of their land are acts of discrimination. Fiji should recognize native Fijian group rights, as well as recognize the rights of other communities and individual rights, and make sure that none topples the other." I hope that I have been very clear to you all on the legislations that have been passed from 2006 to now that manifest the motive, the very clear motive by this government to take away and remove indigenous rights of native Fijians generally and to their land. And I must say that having read the thesis of Mr. Ayaz Kayum, I can almost prove to me that these legislations are manifestations of the conclusions, and they are clearly based on the conclusions and recommendations that are made in his thesis. I urge you most profoundly to please come 17th of September to please vote very, very wisely, and especially to vote out this government and to allow us to bring back our rights, as well as to immediately repeal all these laws that have taken them away. Thank you very much.